All right, so closing arguments to come. But, folks, when I heard her say that she's not going to put on a case, the defense, I don't get it. I don't get it in cases like this. And you know what? You just have to remember the defense doesn't have to put on a case here. It's the prosecution's burden. They have to prove their case beyond a reasonable doubt. But there is so much to explain here. None of that has gone explained in front of this jury, except, I guess, in closing arguments. But let me bring in-session legal analyst and contributor Sonny Hostin, also Meg Strickler, a criminal defense attorney. And you know what? We were going to talk a little bit about the prosecution's case. We'll do that in a second. But Meg, I want to start with you. You're the defense attorney here. Maybe I don't understand defense attorneys anymore, but I don't understand why there was nothing here put on by the defense. What do you think?
Well, we're a difficult bunch to understand. Let me start off with that.
I understand Meg completely.
But we're a quirky bunch, defense attorneys, so I wanted to say that from the outset.
Fine.
But what makes no sense here is that normally you would have a forensic psychiatrist at the very minimum testify, but I can explain why it didn't happen.
Okay, why? Money. Money.
You have to have...
But you know what? Our viewers would attest to this as well. That's not the way the system is supposed to work.
Oh, I could get on my soapbox.
Defendants are supposed to... Okay, so go ahead.
Here
get on
I
that
go.
soapbox.
There's
because
my
you know
soapbox.
What? He has the right to a trial, to great legal help just like everybody else. But tell us.
Exactly, but you have to have the judge grant you funds. You need to have judge grant you funds for an investigator. You need funds for the forensic psychiatrist. That is so pivotal in this case. He's 14 years old. We know he's messed up. Look at him in the courtroom. I mean, obviously he's got issues, and we've already heard some of it. That public defender needed to have brought some of that character evidence in, period. But maybe there's no family members, then have the client testify. He would have done a great job because he's only 14 years old. He's not smart enough to be able to try to manipulate the system. He would have been himself, which by definition is dysfunction. He would have shown it well.
I don't know about that because he tried to manipulate those investigators about 5-6 times. That didn't work, so now he's going to get on the stand.
He did horribly with those investigators. Did you hear his voice cracking?
Yeah, no, I heard that.
That's a kid. That's a kid talking.
But still, and you make a great point, Sonny, I want to turn to you. The defense not bringing a case. Tell me what your thoughts are in that, and then I want to talk a little bit about whether or not he should have testified. But give me your sense of that.
You know, I completely agree with Meg. I mean, you're fighting for someone's liberty in a matter like this. He's only 14 years old. You know, I think you have to put a case on. You have to find someone that'll look at the case without charging. You just have to do more in a case like this because he does, I think, try to manipulate those investigators. You see it, but he doesn't do it well. I agree with Meg. And I think the jury needs to understand what this kid is about, how he came to be this person, and there's no explanation there. And that's very troubling to me. I mean, I would suspect perhaps there's an issue in terms of funding, but when you have a public defender, my experience is that public defenders' offices do have ways of finding experts. And so I think it was a big mistake for the defense.
You know, you have to get somebody up there explaining his state of mind. This is a state of mind crime, and they've got nobody explaining what was in his head. Not only that, there is a mountain of evidence against Aaron. Take a look at Amanda Callahan. You remember the victim's sister. She took the stand. She talked about when she came in contact with Aaron on the day of the shooting. Take a look at this.
At what point do you come in contact with Aaron?
When I was closing the back sliding door, he had come in the front.
Okay, and did you notice anything out of place around the computer?
Yes.
What was out of place?
The computer chair had been knocked over, and there was stuff all over the carpet.
Okay, and did you know what that was?
Not at the moment, no ma'am.
Okay, what, if anything, well, let me ask you this. Did you come to find out what it was?
Yes, ma'am.
What was it?
It was along his blood.
Now, when I heard that testimony, Meg, there were a lot of things that went through my mind. Was there a struggle? What happened afterwards? The one thing that didn't come into my mind is, oh, you know, Darren just kind of did this by accident. It kind of happened, as opposed to the prosecution here saying this was premeditated. So you talked about him taking the stand. You talked about him just being himself, a 14-year-old, yet couldn't he have gotten up on that stand? And I'm just going to take the defense's side for a second here. Couldn't he have gotten up on that stand and tried to manipulate the jury in the courtroom and fall on the same result? And therefore, you know, he would have no chance after that.
Well, I don't really think anything he would have said would have helped him because he is just 14. Even if he came off manipulative, he's 14. His voice would have cracked out there in front of the jury, which would have really helped explain, I'm 14 years old. My brain hasn't even fully developed yet. It wouldn't have mattered what he would have said, in my opinion. If he just got up there and talked about it, he could have said, I was scared. He's got a lot of issues. We know that. If you look at his face, it's completely haunted. He's dissociative completely. He's not present. He's 14 years old, but yet he's got an incredibly bad background. All that can come up. And what's interesting, too, on that, when the sister was testifying, on cross-examination, we could have brought more character evidence in that way, too.
Right.
Nothing came in. It's a
Nothing.
very interesting case that way.
Interesting in a way that just makes you shake your head on the defense's side. Now, Diana Chitty, you talk about his background. That was his half-sister, his guardian. She talked about the drama that Aaron Schmidt had in his life.
Aaron, he had a lot of drama in his little young life, and he started just getting in a corner and just wailing and just rocking. And then he would be up under a chair in a fetus position, and he would just be crying, and I'd beg him to come out from under there, and he wouldn't.
Now, Sonny, I understand this young man has had a lot of drama in his life, but I remember the first day we took calls on this case, and people were calling in, our viewers were saying, you know what, I knew somebody who had an abusive background, I had an abusive background, and I never did something like this. This is not something that anyone I know ever thought of doing, even despite their background. Do you think that the jury may look at this and say, you know what, we can't penalize him for malice murder here because of his background, or do they separate the two and say, hey, this young man brought a gun to a home and it ended in a young girl's death?
You know, I struggle with that, but quite frankly, I don't think they have enough of the dysfunction in front of them to even consider it. And I think that was a mistake by the defense. And, you know, Ryan, I agree with those sentiments in terms of there are people that are abused that do not become abusers. And there are people that are abused that do become abusers. And so oftentimes it's an argument that falls very flat in the courtroom. And having tried so many child sex crimes, I've seen defense attorneys make that argument in sex crime cases where there have been defendants that have been terribly abused and go on to abuse children. And it falls flat. It typically doesn't work. But again, in this case, I don't think there's enough evidence in front of this jury to even have them take mercy on him because of his background. And I'm just very surprised at that, because I know when I was prosecuting cases, oftentimes if the defendant got on the witness stand, all of that would come in. And it does, in my view, typically help, because when you speak to jurors after a case, and I didn't necessarily do that, but my colleagues did, oftentimes they sort of hone in on that moment when they get to know the defendant, when they get to hear what happened to the defendant in his own words or her own words. And I just think it was such a missed opportunity in a case like this, when you've got a 14-year-old on the, in the courtroom.
Yeah, and imagine what he would have said on that. So both of you think he should have taken the stand. Now, you talk about the character evidence and the people that knew Aaron Schmidt. Well, take a look at this. Aaron Schmidt's cousin got on the stand and talked about how Aaron gets mad when he's in trouble.
Aaron, he's one of those people that somebody has to listen to him, because if they don't, he'll hold it inside. And that's something that you don't want to see with Aaron, obviously. He never showed no aggression towards me, but he did have some anger problems. Recently, I mean, I didn't see nothing out of ordinary, but when Nanny was getting on to him, it's like he just gets so mad. He's just like, don't you get on to me. But I mean, he's always been like that. If he gets in trouble, he just gets mad. He don't get sad that he's in trouble. He gets mad.
So, Meg, obviously not a good fact for Aaron, but take us through malice murder here, because as I look at this case, you see the mountain of evidence against Aaron, yet I think about what he did afterwards, even talking to the police. Am I going to get in trouble for this? Some could argue that he walked in that house. Maybe he had an intention, maybe he didn't. How can we know what was in his head? And afterwards, he's trying to cover it up. Maybe the jury looks at this and says, hey, where's the plan? Where's the premeditation in all this, other than bringing that gun to that house?
The biggest thing here is that lesser included offenses is what really should go in the closing arguments by the defense. They say, did he really premeditate this? Can we get second degree? Can we get voluntary manslaughter? That's what his background, again, comes back to. He could have snapped.
Right.
When you have PTSD, you snap, you whip out. Does everybody? No. He obviously did. It goes to a lesser included offense here, and I think that's what should vie for in her closing.
And we always talk about, even if he walked in that home with that gun, where did the premeditation start? What did he plan in all this? And it could really affect how they offer these closing arguments, and we'll see what happens with the lesser includeds as well. All right, Meg, Sonny, thank you so much. Folks, we're going to head back to the courtroom. Closing arguments coming up in Aaron Schmidt's murder trial. There's going to be a unique twist when the defense goes first. We'll be right back.